Two Nigerian properties located in the United Kingdom are on the verge of being taken over by a Chinese investor following an order granting the investor the right to enforce a $70 million investment treaty award against Nigeria. The investor, Zhangguoshan Funchin Industrial Investment, was granted final charging orders over two UK residential properties owned by Nigerian government after the company also attached a £20 million debt relating to high-profile P&ID case. The Chinese firm secured this order on June 14 when Master Sovereign in the Commercial Court in London granted the orders in respect of two Liverpool properties estimated to be worth a combined £1.7 million. According to the judge, the order was premised on the fact that properties have been converted to commercial use outside Nigerians' diplomatic or consular activities in the UK, stressing that enforcement of the order should prevail. The high-profile case was a gritty legal battle between Zhangguoshan, represented before the court by waiters and barristers at 3VB, while Nigeria was represented by a Spear Patton Borges and a barrister at Atkins Chambers. Sources say the underlying arbitration was in relation to a joint venture with Nigeria's Ogun State to establish a free trade zone near Lagos in 2013. A Zhangguoshan subsidiary held a 70% stake in the project, but Ogun terminated its participation 3 years later. In 2021, a London-seated UNCITRAL tribunal chaired by Lord Nomberger, including Matthew Jering Casey and Rotimi Ogunsiyasan, said Nigeria was guilty of exploitation and other breaches of China-Nigeria bilateral investment treaty, and ordered the country to pay $55.6 million plus interest and cost. Nigeria in the same year put a challenge against the award in the Commercial Court on jurisdiction grants. Nigerian position was that the arbitration clause in the BIT was invalid, but in later development, Nigeria withdrew the challenge before a hearing on Zhangguoshan's application for security and security for cost was about to take place. Ms. Justice Cockerell in the same court granted Zhangguoshan an ex parte enforcement order in December 2021, but Nigeria did not file against this order within the 74-day deadline allowed by the law. In July 2023, the Court of Appeal in London stopped Nigeria from bringing a late challenge to the enforcement order, stressing Cockerell's provision determination that state immunity did not apply had become final. The investor reportedly got interim charging orders in June and August last year over the two properties in Liverpool which are owned by Nigerian government. Nigerians' effort to dismiss these charging orders filed as Master Slovenia in her judgment held that the properties are leased to residential tenants and that no consular activities are actually taking place on the premises. She also dismissed Nigerians' arguments that it had not been properly served with the interim charging order applications under the State Immunity Act, and that Zhangguoshan had failed to give full and frank disclosure when seeking them. So you see what is happening. This is a total case of breach of agreement. So when you are having an agreement with people, it's always good to take time to review the agreement. And if for any reason, the main reason why you reach this agreement need to change, still go and sit with the people you have this agreement with, renegotiate this agreement before going outside what was agreed to start doing something else. Yes, because that is the case or the dilemma Nigerian government find itself in concerning these two properties. Yes, so with time we will see if these Chinese investors will have victory in terms of seizing these properties that belong to Nigerian government, or if Nigerian government can find their way out of it and regain these properties by maybe paying money fine, but it's only time will tell.